You think the minutes of the Board of Trustee meetings are just paperwork, a formality somebody types up after the real decisions are made. They are not paperwork. They are the legal record of your trust, the proof that it is operating as a trust and not as you wearing a costume. A trust that meets, decides, and signs its minutes looks exactly like what it is. That gap between a trust that exists on paper and a trust that operates is closed in the meeting room and on the minutes page. That is what you came here to learn, and that is what this video delivers. Minutes record the major decisions of the trust. Decisions involving beneficiaries, certificates, the purchase and sale of assets, insurance policies, and any disputes. That record is the trust's legal record. It shows the substance of each transaction. It confirms in writing that the trust is operating as a trust. Rewind that because it's the whole game. A trust earns its protection by behaving like one. Decisions get made by the board. Those decisions get documented. The documentation gets signed. When that pattern is on the page, your privacy and your protection rest on solid ground. When it is missing, you are asking the court to respect a structure you never actually operated. This is why thorough documentation of core issues is critical. It is the difference between a trust that controls and protects and a pile of forms in a binder. You did the hard part by setting the structure up. The minutes are how you keep it alive. They summarize the key points, the considerations, and the resolutions discussed. Then all trustees sign the completed minutes to confirm their agreement. A decision is not finished until it's written down and signed. A well-written minutes includes relevant background details and flow logically from one meeting to the next. That is not always possible, given the time that passes between events, and that's fine. What is not optional is thorough documentation of the core issues, especially when a new trustee steps in and has to get up to speed. In fact, reading the minutes is the first training assignment for any incoming trustee. The minutes are how the next person learns to run your trust without you in the room. Minutes matter most when decisions are complex and several subjects are on the table at once. They keep everyone aligned. Board members refer back to them to confirm a task was completed or a deadline was met. They are the record when there is a disagreement. Who is responsible for what? Listen, how you treat every meeting, especially when a recurring problem spans 2 or 3 years and keeps repeating in the Board of Trustee meetings or general managers meetings, that detailed documentation can be the deciding factor in preventing a lawsuit. The opposite is just as true. If those minutes were not recorded carefully, they become evidence of wrongdoing instead of a shield against it. Same event, same binder, opposite outcomes, decided entirely by how well you write it down. At an absolute minimum, produced at least one set of minutes per year to keep the trust in compliance with legal procedures. If this is the first time anyone has ever explained those minutes carry that much weight, do future you a favor and subscribe so the rest of this indenture series lands in your feed. And stay with me to the end of this one, because the master agenda format coming up is the part you will actually keep on your desk. For now, let's run a meeting the right way. The real advantage of a well-run trust is not only the written record, it lives in how the board interacts and how seriously the members take their responsibility and conduct trust business. Put plainly, the more meetings you hold, the better your trust is managed. Meetings are where trust business actually gets done. When funds are short, trustees may agree to meet and defer their compensation until the trust builds adequate cash flow. The point is that you meet. Money is not an excuse to go silent. Board of Trustee meetings are also educational opportunities, and every real meeting starts with one thing: the agenda. When a group convenes, orderly discussion is essential. Without it, you get chaos. A prepared agenda keeps the meeting on track and ensures every participant comes ready to engage. Attach financial statements, charts, tables, and any supporting documents directly to the agenda. Do not leave them loose. Loose pages create confusion. Number every page. Whoever leads the meeting keeps the group focused on each item in the ordered list, because if the meeting wanders, the person drafting the minutes cannot accurately capture what was decided and in what sequence. Remember these first 2 rules: shredding. A meeting packet can run 10 to 15 pages, and board members write notes on their copies. Unless you absolutely must keep them, those copies, especially the financial pages, get shredded after the meeting. Second is the legality of the originals. All documentation is attached to the final signed minutes and filed in the trust book under the minutes section, using clean copies only, with no handwritten notes. As unlikely as it sounds, the trust book can become part of a lawsuit, and it is the originals, not the copies, that get subpoenaed. This next part is the master format. Most Board of Trustee meetings will not cover every item. Treat it as a starting point and adapt it to the meeting in front of you. Administration, general and educational matters, including any board member training, policies. Not every trust has formal policies and procedures, but the board meeting is the right time and place to create or review them. Protector. The protector usually does not attend, but the agenda should confirm the protector has received recent minutes and that there is a process for keeping every member updated. Recent minutes. Finalizing minutes take a draft review, then assign final copy from all trustees, which require coordination across conflicting schedules. Putting status of the last minutes on the current agenda keeps prior minutes from being overlooked and tend to produce a more complete current agenda. Trusts frequently cover medical insurance and physical well-being of beneficiaries. Long-term and catastrophic care decisions affect both board members and beneficiaries and can take over a year to resolve. Next Board of Trustee meetings. Set the date for the next meeting at the start of the current one, even if it is 4 to 6 months out, because it gets forgotten otherwise. Ongoing education of the board. Review court cases and news on trust matters, durable power of attorney issues, and any fictitious names chosen for the trust. Complex areas like quasi-contracts are covered here, so trustees understand that verbal commitments carry binding force. Pending legal matters and active negotiations belong here too. Present a standard balance sheet and profit and loss statement when reporting to beneficiaries. Banking goes first. Signatures, wire transfers, certificates of deposit, money market accounts, and interest rates. The balance sheet lists bank balances, principal investments, and their current value and liabilities, and reflects total equity as of its date. Profit and loss captures cash in and expenses out. A note from experience: money discussions get emotional. So when the board is tense, place financial last. Otherwise, the meeting can end before the critical decisions are made. Trust certificate register. Review the current register on every agenda and discuss any changes to certificate holdings and decisions affecting trust capital unit holders. Asset holding trust status. Each asset holding trust under the management trust is reported separately. If a property's repair and maintenance list is extensive, schedule a separate meeting for it. The status of the holders of units of beneficial interest is addressed here as well. Run your meetings against this format, and your minutes practically write themselves. In order, complete, and signed. That is a private trust that operates. So now you have everything in one place, and every piece exists to make your next step simpler and safer. Subscribe to Wealth Locked In and click all so each episode reaches you when uploaded, and YouTube won't decide if you see the next video. Watch the full video, start to finish, because the master agenda format that we went over only protects you when you use all of it, not half of it. Pause. Join the school community waitlist to get inside the room with people building and operating real structures. Download the free What is a Trust ebook linked in the description. It's been beefed up a little bit, so I hope you like it, because once you see that a trust is a contract and not a registration, the minutes finally make sense. And grab the Trust Book GPS pinned in the comments. It is your map for assembling the very binder we have been talking about section by section. You now know how minutes are created, how every trustee signs them, and why they are the first thing a new trustee reads. You have the master agenda format that turns a tense, wandering conversation into an orderly, documented, defensible meeting. The structure you built is no longer just on paper. It is alive, it is running, and it is protecting what you built. In the next video, we open the protector's role, the legal duties, the meeting coordination, and the grantor protection that hold the whole operation together. You have learned how the meeting works. Next, you meet the person who makes sure trustees are productive. And I'll see you over there. Peace.